Good afternoon. Welcome to the August meeting of the Trust and Estate section. I'm Andy Kushner, co-chair of the section. We have a few housekeeping items to go through before we get started with our program. The first you see on your screen now, we wanted to make sure you're aware that there is a BHB membership available for everyone. I'm not going to go through all the different tiers, but I do want to call your attention to the Sustainer tier that's in the middle of the page. It's free for law students and attorneys in the first 3 years of practice. So a great value, and this slide will actually be available with more information in the materials that you'll receive after this program. In fact, you'll receive your MCLE certificate, materials, and a copy of the program within a week. After the program, please take a moment to complete the survey. A survey link will pop up right after we conclude this webinar. The Trust and Estate section and all of its webinars are sponsored by the Sanborn team, Geffen Real Estate, Glen Oaks Escrow, and California Title Company. The Sanborn team has been sponsoring the Trust and Estate section since 2006. Servicing clients for over 35 years, the Sanborn team gives members and colleagues attractive results and peace of mind with a depth of knowledge of probate, trust, and conservatorship unparalleled in the industry. The Sanborn team's ongoing sponsorship demonstrates a tangible commitment to the probate and trust community and the Beverly Hills Bar. They are ready to handle any and all sales of real property in Southern California. Think of them as the first resource for your real estate needs. Our second sponsor is Geffen Real Estate. Please welcome Orit Gadish of Geffen Real Estate. She's here live to say a few words. Orit?
Thank you, Andrea. Hi, my name is Orit Gadish. I'm the owner and broker of Geffen Real Estate, a commercial and residential real estate brokerage. I'm based in Beverly Hills, and I have a team of 24 agents who are located throughout Southern California, and we specialize in the probate and trust space. I'm the single point of contact for my clients, and I look forward to connecting or reconnecting with all of you. Thank you for having me.
Thank you, Orit. Our third sponsor is Glen Oaks Escrow. And I'll wait for a second for that page to come up. Great. Marcine Klein is a full-service escrow officer specializing in probate, trust sales, conservatorship, and both court and independent administration of estate act transactions. On a daily basis, Marcine works to ensure that even in the most challenging escrows, close smoothly and that our clients are beyond happy with their experience at Glen Oaks Escrow. Our final sponsor, California Title Company. California Title Company provides comprehensive and timely title insurance protection for home buyers, including first-time home buyers, sellers, veterans and military personnel, seniors, real estate agents, and brokers, mortgage lenders, and commercial real estate professionals. So thank you to all of our sponsors for your support of the section. And I will now turn it over to our legal updates co-chair Dina Nam for our legal updates.
Thanks, Andrea. Good afternoon, everyone. We have one really quick update to provide for you today. The case is called In Re Clifford Brace, and it comes to us through the California Supreme Court from, of all unlikely places, the bankruptcy court. In this case, what had happened was the Ninth Circuit certified a question to the California Supreme Court, asking it to determine which presumption applies to property acquired during marriage, even though title was taken as joint tenants. What had happened in this case is one of the spouses submitted for bankruptcy in 2011, and the trustee was trying to reach their personal residence, which they had taken title to as joint tenants in 1977 or 1978. This was a clash between Family Code Section 760 and Evidence Code 662. What the court ultimately found was that the presumption of community property applied in this case, even though title was taken in joint tenancy. The court did note, however, that the presumption could be rebutted, but the primary presumption that applied in the first matter was the one of community property. And this was filed and came down on July 23rd, 2020. And so with that, I'd like to introduce Joel Goldman, who will then introduce our speaker for today. Thank you.
Thanks, Dina. We're very fortunate to have Steve Trytten as our speaker today. Steve is a partner at the law firm of Henderson, Caverly, and Trytten, working out of their Pasadena office. And his accolades are far too numerous for me to report without taking up too much of his speaking time. But as a brief summary, Steve is a nationally renowned authority on tax and estate planning, having spoken at ACTEC, Heckerling, and the Hawaii, NYU, and USC tax institutes, among others. Steve has been recognized nationally, being included in the Best Lawyers of America, as well as locally as an LA County super lawyer. He's specifically recognized for his expertise in planning surrounding retirement plans, which makes me and hopefully all of you particularly excited for today's presentation. So without further ado, I will turn it over to Steve.
Thank you, Joe. And hi, everyone. It's a pleasure to be with you today. So we're going to talk today about the Secure Act, which made some big changes for those of us who do estate planning with retirement plans. Before I dive into the Secure Act, I'll just mention some current developments. As soon as I get my computer to respond, there we go. There were two notices that came out from the CARES Act. I just want to make you aware of it. We won't spend too much time on them. One of the CARES Act provisions allowed extra distributions from retirement plans that are coronavirus related. Notice 2020-50, released in June, gives more guidance and background on how those provisions are implemented. Another CARES Act provision, 2203, waives required distributions for the year 2020. And that notice has a lot of very interesting guidance in it. Just to hit on some of the highlights, the procedure, they focus a lot on people who took minimum distributions before the CARES Act, before they realized they weren't required, and how those people can put those minimum distributions back into their plans if they want. The procedure is different for retirement plans than for IRAs, and the deadline to do it, August 31, will work for both retirement plans and IRAs. But if you call it too close, if you go a few days past August 31, you may have a chance with a plan, but not with an IRA. So if you have a client that's putting back a minimum distribution, be sure to check this notice out. Another surprise in the notice is people who took minimum distributions from inherited IRAs are also allowed to put those back. That's a gift from Treasury. They probably didn't have statutory authority to offer that, but they've offered it. So people in that situation can do it. Okay, the rest of our time today will be on the Secure Act. And the Secure Act has a lot more in it than what we're going to cover today. We're going to spend about 90% plus of our time on how the minimum distribution rules work after the owner of the plan or IRA account has died. We're going to use a few defined terms. This list is just for reference. It's there for those of you who got the PowerPoint and refer to it later if you need to check on an abbreviation. So there's a few changes in Secure Act that also relate to minimum distributions. I'm going to cover those first, and then we're going to really zero in on this important area of post-death distributions. So one other change in the Secure Act, 72 is the new 70 and a half. And what this means is the point in time where you have to begin your minimum distributions as a living plan owner or IRA owner has changed. Under the old rule, by the way, that magic day is called the required beginning date. Under the old rules, it was April 1st after the calendar year in which the owner attained 70 and a half. Under the Secure Act, that is now pushed back to April 1st after the year in which the owner attains age 72. There's an exception for retirement plans only, not IRAs. If you are a non-5% owner of the company that sponsors the plan and you retire after 72, that postpones your required beginning date until you retire. And surprisingly, we don't even have a definition of retirement in the rules that govern this provision. So there's probably a little wiggle room to decide what that means. The effective date on this is for anyone who attains 70 and a half after 2019, the new age 72 rule will apply. Another change, before under prior law, to put money in an IRA, your own, $6,000 a year contributions, you had to check several boxes. One of them was you had to be under age 70 and a half. They've scratched that box off the page. The other boxes remain. You still need to have compensation income to cover whatever you're contributing. And there is a phase out if you're covered by an employer-sponsored plan, but at least your age is no longer one of the requirements. This is also effective after 2019. Now here's an area where 72 is not the new 70 and a half, and this is the area of qualified charitable distributions, or QCDs. This is where, if you meet the requirements, you can direct a distribution from your IRA directly to charity. Now you have to be over age 70 and a half to do that. There's some other requirements. It has to be a public charity. The maximum amount is $100,000 per year. But they did not push that age back to 72. However, they have a complicated reduction of the 100,000 for someone who is making a qualified charitable distribution and is also benefiting from post 70 and a half IRA contributions. That's explained in the slide. I think just knowing there's some interaction is the main takeaway. And any client who's actually doing both of those things needs their CPA or income tax preparer to be tracking both the post 70 and a half IRA contributions and the qualified charitable distributions. From here on out, we're going to be talking about the new post-death required minimum distribution rules. And a few preliminary comments. It's really important for you to understand Congress could have done a restatement, talking like an estate planner. Sometimes when we amend a trust, we rewrite the whole thing. We call that a restatement. And it all makes sense and it's all coordinated. Or Congress could have put a Band-Aid in the form of an amendment. And then you have to look at the old and the new to really know what the rules are. Well, guess what Congress did? They went with the Band-Aid amendment. So to understand the post-death minimum distribution rules, first you have to master the existing rules, the pre-Secure Act rules. You still need to know all of those rules. Then you have to learn what the Secure Act piles on top of that. And then you have to operate with those together. And if that isn't confusing enough, the amendments are made to Internal Revenue Code Section 401A9. The Secure Act has its own numbered provisions, and they put these amendments in Secure Act Section 401. So if you're not confused yet, you're really good at keeping track of things. I had the privilege of being a co-chair on an ACTEC task force, and we worked very hard, almost full-time job for about 3 months, putting together our comments to Treasury, because we believe there is a lot of guidance needed and a lot of unanswered questions about how the Secure Act works. For those of you who are getting copies of the PowerPoint, hopefully that's all of you, you can use these links to save you a minute, but the task force submissions to Treasury are on the ACTEC website. They're pretty easy to find under the section for government submissions. Now, a really key concept, both under the existing law and the Secure Act law, is when we talk about a designated beneficiary, it has a very specific meaning under the regulations, and it's more specific than just who did you fill in on your designation form. A designated beneficiary under the regulations is an individual, which means they've got a life expectancy, which was really important under the existing rules. They are either designated as a beneficiary under the plan, or they take by the terms of the plan itself. And their designation would be an affirmative election by the employee. You can see a cite to the regulation. So when we refer to a DB or a designated beneficiary, we'll always be using that very specific meaning. So what did the new post-death minimum distribution rules do? Well, first of all, they only changed the rules for DBs. See, we're using that term already, of defined contribution plans, and IRAs, and references to IRA always include Roth IRAs. So a pension plan is a defined benefit plan, and these rules don't even apply to that. But a 401k plan or a profit sharing plan are two examples of defined contribution plans, which these new rules will apply to. The rules for non-DBs did not change. So if I die before my required beginning date with a non-DB, and what would be a good example of that? A charity. If I die with a non-DB, it's still the 5-year rule. So my plan has to be out by the end of the 5th calendar year following the calendar year of my death. If I die on or after my required beginning date, there's some confusion on this, but it's not the 5-year rule. There's another rule. And the other rule, again, Congress is getting very creative here. You look up the life expectancy, my life expectancy, even though I've just died, and you use that life expectancy. So if I die at age 75 and the tables say I've got 9 more years, well then that's what you use for the non-DBs minimum distributions. And more commentators are calling this method the ghost life expectancy method. Spousal rollover rules did not change. So the new rule for DBs is now they have to use a 10-year rule, which works just like the 5-year rule. In fact, the Secure Act even talks about substituting the number 10 into the existing 401A9 provision that had the 5-year rule in it. So we've asked for guidance and regulations, which hopefully will be granted, that it will work the same as the 5-year rule regulations work, which means it's not literally 5 or 10 years after death, but it's the 5th calendar year, meaning we have all the way to the end of a calendar year. We expect that the amounts only have to be out by the end. There's no requirement whether you take some of it sooner than the end of the 5 or the 10-year period. And there's an interesting question. So under existing law, I'm on the last bullet point of this slide. Under existing law, if I die with a designated beneficiary who's older than I am, under existing law, my ghost life expectancy applies if it's longer than my DB's life expectancy. We've asked for guidance under the new rules. How does that work? Because it's now an apples to oranges comparison. The ghost life expectancy has a requirement every year. The 10-year rule, it only comes out at the end. I'm not sure what Treasury will decide on this, but keep your eye on that. This is an important rule. We're going to need to know how that works. Now, Congress made some exceptions. They decided they didn't want to beat up too hard on certain DBs. So there are exceptions for 5 categories, and they're referred to in the law as eligible designated beneficiaries, or for short, EDBs. So in these slides, the owner of a retirement plan or IRA is generally called the participant, or P for short. So the first category is the participant's spouse. The second category is the participant's minor child. Note that that's not just any old minor child. It has to be a minor child of the participant. That could be relevant in a blended family. And also, there's no move-up rule like GST. So if the participant's child has died, leaving minor grandchildren, they don't qualify for this exception. It's literally the participant's minor child. The third category is a disabled individual. We'll go over that definition later. The The fourth category is a chronically ill individual. We'll also go over that. The fifth category, I guess Congress didn't want to beat up on, are people who are less than 10 years younger than the participant. Not quite sure what the policy reason is there. The determination of whether you fit into one of these categories is made at the participant's death. So if you're healthy at death and you become disabled later, you do not get to fall into one of these exceptions. Now, an eligible designated beneficiary does get to use the life expectancy method instead of the 10-year rule, but only while they're alive. After they die, you switch to a 10-year distribution period. With one exception, on the participant's minor child, they only get to use the life expectancy until they reach majority. And then it switches to the 10-year rule after they reach majority. By the way, there's an announcement I meant to make at the start, and I'm sorry it didn't occur. But if you have questions, put them into the chat function. And when I reach the end of the presentation, I'll try to answer as many of them as I can. Okay, pressing on. We talked about majority. Well, how is majority defined? You know, different states have different ages. Well, because Congress was in Band-Aid mode, they were looking for an existing definition in the code, and they found one, and it's in the pension area. Up until now, it has never been used for minimum distribution purposes. And you'll see that definition here on the slide, and there's two very interesting, actually three very interesting things in this slide. The first is they still don't tell you what the magic age is, so if it varies from one state to another, we still don't know exactly how that works. We've asked for guidance on that. But notice what they do say is a child is treated as not having reached majority if they have not completed a specified course of education and they're under age 26. So it sounds like depending on what's going on with their education, they could be, may not be a majority until age 26. We've asked for guidance on what specified course of education means. We also suggested to Treasury that they consider just setting at age 26 for everybody. That would be a great outcome if they decide to go with that simple approach. There's one other rule that's very important here. If a child is disabled before they reach majority, they can be treated as having not reached age of majority as long as they continue to be disabled, which in some sad cases could be for a very long time. Now, for a lot of these people, we're going to want to designate trusts. All of the see-through trust rules that we have learned already, they haven't changed. We have to apply them knowing that there's different distribution periods than before. But the see-through trust rules are the same. And here's a quick summary. For a trust to be a see-through trust, it has to meet 4 threshold requirements. They're not hard to meet. It has to be valid under state law. It has to be irrevocable. The beneficiaries have to be identifiable, and naming a class satisfies that requirement. And there's certain documentation that has to be turned in to the IRA custodian or the plan administrator no later than October 31 of the calendar year after the year of death. If you check those 4 boxes, you get past the first bullet on the slide. And as a see-through trust, what that then means is we can look through the trust. Because I should have mentioned at the beginning, the general rule is that only individuals can be DBs. And anything other than an individual, like an estate or a charity or a trust, doesn't count. But the see-through trust rules creates an exception for certain trusts. And certain trusts that meet those 4 threshold requirements, you're allowed to look through the trust as if the trust beneficiaries had been designated. It doesn't mean you're home free. It kind of depends on who you see once you look through the trust. You're also required to treat the beneficiaries as a group. You can't have a separate analysis for each beneficiary. You then use, under the existing law, you use the shortest life expectancy, or if there was a non-designated beneficiary, you didn't get a life expectancy. And in figuring all that out, there were certain beneficiaries that you could disregard if they were mere potential successors, and that's been a very controversial provision. It's very hard to interpret and apply that particular rule. Then in the regulations, they give us a safe harbor called a conduit trust. And you won't see the word conduit in the regulation, but the concept is if the trust cannot accumulate, if any money that comes out of the retirement plan passes through the trust and out to the beneficiary without being accumulated, they will let you treat that sole beneficiary as the only life, which makes it easy to apply the minimum distribution rules, or at least it did under existing law. I've seen a few conduit trusts come across my desk that had more than one current beneficiary. Warning, I don't think that's safe. The regulations show it as having one. I would follow the well-beaten path on that point if you possibly can. The other thing, I've seen a lot of conduit trusts cross my desk where they only passed out the minimum distributions. That's not enough. Any distribution whatsoever that comes out of the retirement plan has to get passed out to the beneficiary to qualify as a conduit trust. Now, when are these new rules effective? Generally, for anyone who dies after 12/31/2019. Government plans get 2 extra years. We won't run into that very often. And even rarer is the collective bargained plan. And that's a case-by-case rule that will depend on when the last collective bargaining agreement was put in place. But there's some fine print. Congress hid a retroactive revenue raiser in the effective date provisions. And here's how they did it. If the participant dies before the effective date, so let's assume this is a normal plan, it has a 12/31/2019 effective date, participant dies before that, he has a designated beneficiary who uses the life expectancy under the old rules. But now let's say down the road, let's say it's the year 2028, the designated beneficiary dies. Under this revenue raiser, the beneficiary is whoever succeeds that deceased designated beneficiary could have continued the remaining life expectancy under existing rules, and Secure Act is going to make them change to a 10-year period, which in most cases will accelerate the distributions and raise some tax. This provision looks like it wasn't given a lot of thought, and it's very difficult to interpret if there are trusts involved. We've asked for a lot of guidance on that point. So let's go through some case studies, starting with healthy adult children. We're going to start with Paula. She's a single parent. She has one healthy adult child. Her assets are under the estate tax limit. She wants advice on how she should designate her IRA to Pauline. It's a $3 million IRA. Pauline's the daughter. But she does want to know what options might help prevent Pauline from receiving too much too soon. Option number 1, she could designate Pauline outright. Well, under the Secure Act, that Pauline will receive a 10-year rule. She's a healthy adult child. Her distributions, she can decide when she takes them out, and they'll be taxed at Pauline's individual tax rates. Pauline can leave that money to anyone she wants when she dies. Okay, we could designate a conduit trust for Pauline. And the way we would do that, the conduit trust would probably get added into Paula's revocable trust as a sub-trust. And listen up, this is really important. Paula should not designate a revocable trust. She should designate the sub-trust. I can't emphasize how important that is. So let's assume that Paula does all that correctly and dies. So Pauline is the sole DB because of the safe harbor conduit rules and the regulations. But the 10-year rule will still apply, so that comes out the same. And the distributions are going to have to come out of the trust and go to Pauline. So they're going to get taxed at individual rates. That's the same. But what can be different is what happens to that trust when Pauline dies. She can be given a power of appointment or not, and the remainder beneficiaries could be anybody, including charities. So there may be estate planning advantages. Also, the trustee of the conduit trust, if it's not Pauline, can decide when the distributions come out, at least up through the 10th year. But once we get to year 10, they've all come out. They're all going to come out of the trust and go to Pauline. So there's estate planning advantages that I mentioned, may end up not getting used, at least on the IRA, if Pauline lives through her 10-year period. Or Paula, option 3, could designate an accumulation trust. Now, this is the kind of trust that could really protect Pauline from receiving assets at the wrong time. And it could qualify as a see-through trust if you know how to draft accumulation trusts. And this is nothing new. We've been talking about this for years. To cut to the chase, I think using the age restriction method now is probably the best way. So those of us who draft these have clauses we drop into whatever the trust would otherwise be, that then revises certain provisions to make sure that none of the plan or accumulations in the trust from the plan can go to anybody who's too old. And we usually set the age limit, in this case with a sole child, we probably use the child's age. If it's a family with several children, we probably use the oldest child's age. Now this trust can provide for distributions and accumulations, however Paula wants to provide for it. They can be discretionary, whatever she wants to do. We should still get the 10-year rule as long as we have a DB and no non-DBs. We should be fine there. But the accumulations are going to be taxed at the trust level at compressed trust rates, which, depending on Pauline's tax bracket, could be a significant income tax increase. And there's a question whether Pauline's power of appointment needs to be limited so that she can't appoint to somebody older or to a charity. A lot of commentators under existing law have opined that those powers of appointment should be limited. Personally, I've never believed that. I actually think power of appointment really is an enhancement to Pauline's beneficial interest. But in my drafting, I've always followed the majority view to be safe, and my clients are not an experiment just because I see it differently. But we did make a pretty good case in our guidance to Treasury that these powers of appointment really should not be considered when you're identifying who the potential DBs of a trust are. So Paula has another possibility. Let's say she doesn't like all this age restriction stuff and she doesn't like the possibility of having to limit the power of appointment. Well, she could draft something that doesn't qualify as an accumulation trust, and she's only going to end up with a 5-year rule or ghost life expectancy instead of a 10-year rule. It's not that big a change in the outcome. So if there's a term necessary to qualify as a see-through DB accumulation trust, it's a lot more viable now to leave that term out if that's not what the client wants. We only get a little drop down in the benefit. As an example, if she wants charities to be more involved in the trust. Did you see in there any way for Paula to beat the new 10-year rule? They've buttoned this down pretty well. With a healthy adult child, it's very hard to beat this 10-year rule. So what that means is Paula's IRA is now going to be less valuable to Pauline due to the Secure Act. Now, there might be one possible option, but I think this is going to get oversold. So we need to be very thoughtful before we use this option. And that is the Charitable Remainder Trust. So the Charitable Remainder Trust is going to be a non-DB. It'll have a charity in it that we have to count when we look through it. The IRA is going to pay out quickly, but it's going to pay out to the CRT. And the CRT itself is not going to be paying any tax on the IRA distributions. The CRT will gradually make distributions to Pauline over a period of time. And those distributions will gradually move the ordinary income out to Pauline, and it kind of simulates a stretch under the existing law. And there are some people who are excited about this. Pauline will pay income tax at her individual rates. The remainder will go to charity at Pauline's death. Well, I think we have to, like I said, we have to be thoughtful about this. The second bullet on this slide points out one of the problems, which is once you have designed your charitable remainder trust, the distributions are rigid. You cannot give that beneficiary a penny more or a penny less than what's required. And the actuarial value of the remainder has to be at least 10%. So these things are complicated to draft and administer. And some of that money will not go to family at Pauline's death. It will go to charity. So the takeaways are, don't think of a CRT as a way to beat the act. For a family that has no charitable intent, the CRT is not going to put them in a better position. Your poster child client that would be good for a CRT, one, they have charitable intent and this helps fulfill it. And two, they have other assets for the beneficiary where it can be flexible how much they receive and when to supplement the rigid distribution from the CRT. Now we're going to talk about Don. Pretty much the same facts as Paula, but he's got 3 healthy adult children, Frank, Sam, and Tom. Here are Don's options. We can go a little quicker now because we spent some time on each of these. He could mix and match if he wanted to, but you have the outright, the conduit, the accumulation, the non-DB accumulation. And because he's got 3, he also could do an accumulation pot trust for 3, which would get the 10-year rule. Or he could do a non-DB accumulation pot trust, which would get either the 5-year or the ghost life expectancy. Again, on his death beneficiary designation, don't designate the revocable trust, designate the sub-trusts. Now, the separate account rule is something we should talk about. So this last bullet I talked about, or the last 2 bullets, pot trusts, and the ones above that, the conduit accumulation and non-DB accumulation, those would be separate for each child. The way the separate account rule works, if you're naming individuals, you can put them all on the death beneficiary designation, 1/3 each. They each get to use their own life expectancy under existing law. You're thinking, well, everybody's getting 10 years, right? We don't even have to go to that trouble. We could stop designating all these sub-trusts and individuals separately, and we could just designate our revocable trust. Not recommended. There's 2 advantages of still respecting the separate account rule. One example is that the child who's healthy at the time we do the estate planning becomes disabled or chronically ill and is now an EDB. They will only get that life expectancy if they've been designated separately. At least that's what we believe. We've asked for some guidance to confirm that. And the other thing is, for disclaimer planning purposes, you need to preserve an individual disclaimer path for each individual to really have a good chance of dialing in the outcome you want during postmortem planning. Now we're going to talk about Amy. Now, she has the same facts as Paula, but she has a minor child, Andrew, age 3. So he's going to get life expectancy until majority. We're a little fuzzy on when majority will occur, but it'll be at least 18 and maybe as much as 26, or even later if, heaven forbid, Andrew gets disabled. But at least right now, Andrew's healthy. Hopefully that's not going to be a scenario. Then, of course, he will switch to a 10-year period once he does hit majority. Now, she could designate Andrew outright. That would require a legal guardian, or she could use a UTMA account. We've asked for guidance confirming that UTMA accounts are equivalent to an outright designation. We believe that they are. Andrew would get the life expectancy method till majority. They'd be taxed at individual rates, subject to what? The kiddie tax. but outright is really not ideal for a 3-year-old. So what other options do we have? Well, we have the conduit trust. It's a better option, but there'll still be lifetime distributions are going to force out minimum distributions every year, whether this 3-year-old needs them or not. We've asked for guidance whether a conduit trust can have a facility of payment provision that would allow those distributions to come out and go into a UTMA. Not sure how Treasury is going to respond to that. So the conduit is closer and maybe would work, but we still have some questions how much control we have of keeping funds from dropping into a young child's lap. We could do an accumulation trust, but we have to be careful here because by definition, when you look through an accumulation trust, you're going to see more than one trust beneficiary. So let's say the alternate after Andrew is not an EDB. Let's say that's a healthy adult, an aunt or an uncle or cousin or something. I'm worried that that accumulation trust will not qualify to use Andrew's life expectancy method because he is not the sole beneficiary. He is one of at least 2 beneficiaries. Until we've asked for guidance that would allow Andrew's life expectancy. We don't know if he'll receive guidance that allows that or not. And until we do, you cannot assume that this accumulation trust will get the life expectancy method, and you'll have to counsel your clients accordingly. And some clients might choose the certainty of a conduit trust. Other clients might take the uncertainty because they feel strongly that the accumulation trust has the right terms for their young child. This slide reviews this too, the trade-off Amy has to choose between conduit and accumulation trusts. Here's a few numbers about the difference. If you get a life expectancy for a young child, look how low those minimum distributions are as a percentage. Whereas if you're in the 10-year rule, you've got 100% coming out over 10 years. So it's a really big difference. Now, Bob has 3 minor children, Huey, Dewey, and Louie. So what's he going to do? He could do 3 conduits. They'd each get their own life expectancy. He could try to do an accumulation trust, but again, we're going to have more beneficiaries than just these 3. So it's the planning for Bob is going to be challenging too. We probably should keep the trust separate and choose between conduit and accumulation. Okay, now let's talk about disabled and chronically ill EDBs. And it's a little contrived, but I needed an abbreviated term for that. So I call them CIDBs. So what is disabled? And you'll see in this slide, I underlined the elements of this definition. Again, Congress was in Band-Aid mode. They were looking for an existing definition. They found it in 72M7. So a person is disabled if they are unable to engage in any substantial gainful activity. Think about it. That is a severe test. So I used to be a lawyer. Now I can't be a lawyer anymore, but I could flip burgers. I'm not disabled. To be disabled, I have to be unable to engage in any substantial gainful activity. That's a very strict test. And it has to be by reason of a medically determinable physical or mental impairment, which can be expected to result in death or to be of long continued and indefinite duration. That is a tough test, folks. By the way, that happens to be very similar to the Social Security test for Social Security disability. And that test is kind of a gateway to Medicaid and other kinds of programs for the disabled. It's especially difficult to apply this definition to minors who are too young to work. And we don't know yet what Treasury is going to require in terms of how this is certified. We had a phone call with them early in this process where they made a comment that we think suggests they're thinking that the paperwork showing that a person qualifies as disabled actually it has to exist on date of death. That would be almost impossible with children. We've pointed this out in our guidance, and hopefully reasonable minds will prevail. What is chronically ill? Okay, Congress was in Band-Aid mode. They had to look a little harder, but they found a definition in Code Section 7702 Cat B C2, which is normally used where long-term care contracts are concerned. So this definition, they tell you how you do the paperwork. It's certified by a licensed healthcare practitioner as being unable to perform at least 2 activities of daily living for a period of at least 90 days due to a loss of functional capacity or requiring substantial supervision to protect some individual from threats to health and safety due to severe cognitive impairment. You can kind of tell this was written for the elderly. Secure Act further requires that certification is that the chronic illness is indefinite and reasonably expected to be lengthy in nature. They tell you who can make this certification. You can see the options here. This is going to be very hard to apply to young people, particularly minors, because that definition, I'm going to turn back to it in a moment. Look how it talks about a loss of functional capacity. You'll see that right in the middle line. Well, where a minor is concerned, you may have to show a loss of something they never had. So unless they fix that, and that's another guidance point we've requested, I think it's going to be hard to qualify minors as chronically ill. So let's do a case study. Veronica has an adult child, Vicky, who is disabled. She's a CIDB. So let's go through Veronica's options. Well, she could go outright, but those of you who have planned for disabled people, you know outright. There's a lot of things that can go wrong with that. It might disqualify the person for government benefits. It could expose the funds to undue influence by people around that person. Not a practical option. We could do a conduit trust. Well, it's a little better, but those distributions are going to be forced out and eventually could cause the same problems. So we don't really like the conduit trust either. So we could do an accumulation trust. That would be perfect, and even a special needs trust would be great, right? But remember what I said before, there's going to be multiple trust beneficiaries. They're not going to all be EDBs. And we're really worried whether that accumulation trust can use the EDB's life expectancy. Although we've asked for guidance saying that it can, we're really worried about this. And I think Veronica has a similar dilemma as we discussed with Paula and Amy. And Vicky in this case, Veronica is especially worried that Vicky's going to have high financial needs. So we really got to make this retirement plan worth as much as possible. Veronica's really in a dilemma. What can she do? Well, guess what? The National Academy of Elder Law Attorneys lobbied Congress very hard in the fall of 2019. At the 11th hour, Congress added some proposals that had been suggested by the National Academy of Elder Law Attorneys to try to provide some extra help to these people. The new provisions were added right before the Secure Act was enacted in December. These provisions create a new kind of trust you haven't heard of before, called an applicable multi-beneficiary trust. You have to check 3 boxes to qualify. The trust has to have more than one beneficiary, has to be a see-through trust, and all of the trust's beneficiaries have to be DBs, so no charities. And at least one of the beneficiaries has to be a CIDB. Notice that's not EDB. This is only for disabled and chronically ill. If you check those 3 boxes, you are an applicable multi-beneficiary trust, or an AMBT, and you are eligible for 2 special rules that other trusts cannot use. I think it's easier to explain the second rule first. Under the second rule, if under the terms of the AMBT, no one other than a DCIDB has any right to any of the plan until all of the DCIDBs who are beneficiaries have passed away, then the AMBT can use the life expectancy method instead of the 10-year rule. That solves Veronica's problem, doesn't it? Well, there's a catch. Congress got so excited telling us we could use the life expectancy method, they forgot to tell us whose life expectancy we use. And under the existing see-through trust provisions, we would normally use the shortest. So we've got a glitch here. We've asked for guidance on it. I'm a little more optimistic that Treasury will confirm that we get to use the DCIDB's life expectancy, but you can't assume anything. So there's a precaution that you should use for a client like this. Do an accumulation trust where your DCIDB is the oldest life. You have an age restriction. That's not perfect, but hopefully that will hedge your bets a little until we get this guidance and we know for sure what the rules will be. A little more discussion of it on this slide. In the interest of time, I'm going to press on. I'm going to also press on here. So you remember Bob? We had 3 minor kids, Huey, Dewey, and Louie. So now we're going to change the facts for Bob, and the middle child, Dewey, is disabled as a DCIDB. The other 2 are minor children. They're just EDBs. So what are Bob's options now? One of the things I want to focus you on is because different kinds of beneficiaries can get different rules, we may find situations where we want to target as much of Bob's IRA as we can to Dewey, because it's more valuable to Dewey than either of the other 2 children. If Bob has enough other assets, we might be able to designate the whole IRA to Dewey and then provide for the other children with the other assets. The way we would do that, of course, is with an AMBT. It'd be an accumulation trust with Dewey as the sole current beneficiary, and if we're doing it before we get guidance, Dewey's life will probably be the measuring life. Now, there is an interesting question here. Let's say we can't get 100% of the IRA to Dewey and still get enough to the others. Well, we could have a death beneficiary designation that describes the percentages that go 2 or 3 different ways. But wouldn't it be cool if someone could decide that at the date of death and we don't have to commit to it ahead of time? Because maybe at date of death, we'd get different percentages would make more sense. Now we're going to talk about the first of the 2 rules that AMBTs qualify for. So under this rule, if you have an AMBT that under its terms will divide immediately on P's death into separate trusts for each beneficiary, wherever that IRA or plan ends up, if it's payable to a DCIDB, it can use the life expectancy method. There is no special rule if it's not payable to a DCIDB. So if the AMBT divides and the DCIDB gets a conduit trust, no question we're getting life expectancy with the DCIDB's life. And notice that we're getting the life expectancy even though this arrangement would otherwise flunk the separate account rule, because remember the AMBT that divides is what got designated and the conduit's what came out of the division. So one takeaway on the first rule is it's a way around the separate account rule for AMBTs, but conduit trust is still probably not the best thing to divide out. We probably would have it divide out as an accumulation trust, and now we're back to the question about whose life. Again, I think Treasury will confirm Congress's intent that it's the DCIDB's life, but until then, I recommend trying to stay within the second rule, which we discussed earlier, and wait to bank on this first rule until we get the guidance we need. But once we do get the guidance, it's going to be a great rule, because it's the only way that I know of that someone can make the decision at death of where the IRA goes, which could be really, really valuable. It's almost like the Clayton Q-tip of IRAs for disabled and chronically ill. Okay, another thing to keep your eye on. Do you remember that the definition of AMBTs, that the key requirements have to be in according to the terms of the trust? I'm worried if that's going to interfere with some of the post-mortem planning we like to do, where we either get terms in that we're missing, or maybe we take terms out that we thought we'd need and don't need. Keep your eye on this. We've asked for guidance, but the safest course is make sure you get those terms into the AMBT, and don't allow trust removers or state decanting rules to allow those required provisions to be able to be taken out. Until we have more guidance, that would be the safest course. A few additional comments. Obviously, we need a lot more guidance on how these AMBT rules work. It may be helpful to include statements of intent in trust documents. If we don't get the guidance that's quite what we're hoping for and somebody dies in the meantime, that statement of intent could be helpful in trying to work out a reasonable outcome. I mentioned the savings clause so that decanting and other things can't interfere with qualification. And I don't know how many of you know this, but there's a higher trust exemption for certain trusts that qualify under 642B2C. And it just so happens that a lot of accumulation trusts and AMBTs might qualify for that. One other point I want to make. The part of the designation beneficiary, the beneficiary designation form, that, there's a primary section and a contingent section. It doesn't cost a penny to fill out both sections. And filling out the contingent section can be really helpful in certain situations. And these slides discuss them in detail. I'm going to actually press on just to stay on track time-wise. But fill in those contingent beneficiary designations. Don't leave them blank. Let's talk about spouses and planning for spouses. Well, with the traditional family, the traditional solution is each spouse designates each other, not their revocable trust. They just designate each other as individuals. And what are they going to eat? Whoever survives to with the deceased IRA, they're going to do a spousal rollover. Under the existing rules, that was a really good deal because the spouse got their life expectancy, and then after that, if they designated the children's life expectancies would follow. Well, it's not quite as good a deal now as it used to be, but it's still a good deal, and it's still what a lot of traditional married families are going to do. Let's do a variation. Ted and Alice have a traditional family, which means that all of the children, both the parents of all the children, but they're over the estate tax threshold. And Alice has a big retirement plan, and she's a little worried about Ted's money management skills. So that's estate planning code for it has to go into a trust. So what are her options to put her retirement plan in trust for Ted? She may want it to be a marital Q-tip trust. So there's a whole set of rules there, not covered in the slide, that you have to follow. There's 3 different ref procs on this that you have to follow that gives the spouse the right to compel pulling the income out of the IRA or retirement plan so that both the plan and the trust will qualify as marital Q-tip property. The most common design I see on these marital trusts is conduit. It could be accumulation as to the principal, but obviously income has to come out. But one of the things you have to remember with a conduit trust is if the surviving spouse lives to or beyond life expectancy. By the way, I should have mentioned the spouse is an EDB. They're still going to get to use the life expectancy. In a conduit marital, they would definitely get to use it. But if they live to or beyond life expectancy, those minimum distributions are coming out are getting to be really large. And this trust that you thought would protect a portion for the children might get very small. So when the remainder beneficiaries are among the priorities, be careful about using the conduit trust. One other thing is watch for the spousal consent rules. There's federal ERISA rules if it's an ERISA plan. And if it's not an ERISA plan, California actually has its own set of spousal consent rules for community property. And a marital trust would normally not qualify under either of those sets of rules without an advance spousal consent, which would need to be done as part of the estate planning. All right, I think I covered some of this. Let's go to a blended family, the Brady Bunch. So Mike and Carol are happily married, but they each brought 3 children from prior marriages into the marriage. They want to provide for each other and then their own children. How could they do this? Well, the conduit Q-tip trust, as I mentioned, there might not be much left for the children if the survivor lives to or beyond life expectancy. But if you do with a non-conduit Q-tip trust, now we have this dilemma. We don't know if we'll even get life expectancy. It might be the 10-year rule. Any other ideas? Well, what if the survivor got all the retirement outright, but then we loaded a lot of non-retirement assets into the Q-tip? That might work. In a community property state, we might even be able to transmute things to get more into one column than the other. Or we could use a rough justice approach, where you split part of the plan or IRA into 2 portions, and one portion goes to the survivor outright and the other goes to conduit trusts for the children. And there's one other option here I should mention, which is the aggregate theory agreement, which may really turbocharge that first bullet where you could get all of the retirement into one column and all the non-retirement into a different column, depending on the circumstances. So there's some interesting planning there, but it's not easy. These are some of the hardest estate plans that we do. Let's move now to charitable planning. The first rule in charitable planning is just because we can doesn't mean we should. We got to be really clear what the client wants. We have to understand their charitable intent. And a client may not have thought about it, and we may do them a service to ask them, if you thought about charities, is that something you want to do? And if they express interest, we can help them develop that. But one way or the other, we got to be clear what they want before we start rolling out charitable planning ideas. So assuming the client does have charitable intent, they could use QCDs during life. Those are a little bit more efficient than taking the distribution and making the gift yourself. We could designate a CRT as an alternative to a 10-year rule for healthy adult beneficiaries. Or we could leave the IRA or plan to the charity and leave other assets to the kids. It's also possible to designate a charity in exchange for a charitable gift annuity, but I've never seen anyone actually do that. But I know that it is possible. Now let's move to Roth IRAs. They got a huge downgrade. They've been downgraded from an amazing deal to a good deal. So the point is, Roth IRAs are still worthwhile. They're just not as fabulous as they used to be. They're really good for young family members who want to start early. They're also good if something else has happened. Maybe you have a big business loss or you've made a large charitable deduction. Great time to do a Roth IRA conversion because the large amount of taxable income from the conversion might offset. I don't want to get into politics, but there are some people who are worried that income taxes might be going up after the election. If that were the case, some people might want to do some Roth IRA conversions to pay more income tax under the current lower rates and protect more of their retirement assets after the rates go up, if in fact that's what happens. And it's pretty powerful stuff. If you have a 50% income tax rate, I'm picking that just to make the math easy. $1 in a Roth IRA has twice the after-tax spending power as $1 in an IRA, because you don't have to pay that 50% tax on the way out. So if you can convert $1 million IRA into $1 million Roth IRA, you've just doubled the spending power of that account. Now you have to pay some income tax from your own assets. That's the trade-off. But if you have enough liquidity and you can afford to pay that income tax, and if you think you're getting a benefit paying it at this year's rates, it might be an interesting move. Don't forget to consider the economics of your assets. If your assets are in the stock market and you wrote it down and now you've ridden it back up, you may want to at least give some thought. How confident are you that the stocks will hold their value after you make your Roth IRA conversion? Or if you're not sure, maybe you hold out and see if the stock market corrects before year-end and then do your Roth IRA conversion. That's the kind of mindset you need as you're thinking about these Roth IRA conversions. By the way, the law changed a while ago. I think it was the 2017 Act, took away the ability to undo a Roth conversion. So once you do a Roth conversion, you're done. There's no going back. The other cool thing about Roth IRA conversions is all of that income tax you're paying is with pre-estate tax dollars. So if you're over the estate tax limit, or if you think you will be after the election, you can actually reduce your net estate by making a Roth IRA conversion and paying some income tax. Okay. Just a quick comment on the excise tax. You know, if you don't take out a minimum distribution you're supposed to take out, there's a 50% penalty. It normally does not compound. So if I miss distributions for 5 years in a row, each penalty is calculated separately. But if I get to the last year of a 5-year period or a 10-year period, and I don't take the whole plan out, it does start compounding after that. And we're going to have a lot more beneficiaries with 5 and 10-year rules under Secure than we had before. So we really need to keep our eye on protecting them from this penalty. Okay, closing comments. Any deferral during life is going to play a larger part of the total value of a retirement plan because we're not getting as much after death. So for those who start saving earlier, retirement still looks pretty attractive, especially if you can get children started earlier with Roth IRAs. Anything that you can do to defer distributions that might make more available to you later in life should be helpful. So retirement plans are not out the window. They're still valuable, but we just have to look at them in the light of these new distribution rules. The other thing to remember is we've got to be clear what the client wants and let that drive the planning. We don't want the tax or the minimum distribution rules to be the tail that wags the dog. And along those lines, some clients say, I put a high value on simplicity. Please don't complicate my plan unless you're really going to hit a home run in doing that. My last comment, we live in uncertain times. We can't focus on one rule and try to optimize the whole plan over one rule. We've got to allow for a lot of different scenarios. We've got to consider a lot of different rules and try to come up with the strategies that will produce acceptable results across a wide range of scenarios, even if it doesn't hit a home run in one scenario. I hope these comments have been helpful. I'm going to check the chat list now. Let me unshare my screen. And let's see what questions we have in the chat list. Okay. Are spousal rollovers still available, or must the spouse use the participant's life expectancy? Good news. Spousal rollovers are still available. They're unchanged. So if one spouse dies and the new spouse rolls it over, the new spouse is treated as the owner of the account, and they use the lifetime distribution rules, which will be that spouse's life plus a hypothetical life 10 years younger. Then when the spouse dies, then we'll go to a post-death distribution regime, which might be 10-year rules. Last chance for questions. I don't see
There's 2 more questions in Q&A if you can check.
Thank you. Okay. Here we go. If the grandparent adopts the minor grandchild, does the grandchild qualify as an EDB? Great question. I believe the answer would be yes. We did ask in our guidance project for Treasury to confirm exactly who is and who is not considered a child. We think they will adopt the state law of the decedent, and in, I would think, almost every state, an adopted person is now a child, and that would work. Great question. The last question is, do my recommendations change for a client with a Roth IRA? I'm not sure which recommendation that would be. But I will say this, I'm a big fan of Roth IRAs and of keeping them going. And so, for example, in the one case study where Dewey was disabled and the other two were healthy, if I have a Roth IRA, I'm going to really look hard at how I can get as much of that into Dewey's trust as I can, because it'll be so much more valuable to him. And if that isn't answering the question that was posed, just email me and I'd be happy to answer it by email. I don't see any other questions. It's a real pleasure being with you today. Good luck. I don't know how many of you remember Hill Street Blues, but at the end of the sergeant's briefing, he'd always say, be careful out there. Thanks. Have a great day. Bye-bye.